And tonight, the father of the teenage girl found in her mother's freezer is talking only to 7 Action News. He wanted to get his side of the story out, so he called our Kim Russell to talk.
Over 2 years. I had to tell my ex. She was never there. And she's sitting right there. She was sitting right there.
Alex Dorsey says he didn't understand why Michelle Blair suddenly stopped letting him take his 2 daughters for visits 2 years ago until this week. That's when police found one of their 2 daughters and Blair's son dead in a freezer in her apartment. Blair allegedly confessed to killing her son Stephen in 2012 and their daughter Stoney in 2013.
He was sitting right there. Lord mercy, he was sitting right there.
Dorsey says Blair would tell him Stoney, who would have been 15 now, wasn't home. He would talk to his oldest daughter, who is now 17, at the door.
So Mom said you can't come in.
7 months ago is when Alex Dorsey says he last came to this porch that is now turned into a makeshift memorial. He says his daughter's mother wouldn't let him see his girls because he didn't have money. He had lost his job.
He was paying his child support until he lost his job. It wasn't like he didn't try.
The state is now trying to take away his rights to his 17-year-old daughter. A petition says he abandoned his girls, failed to take legal action to obtain parenting time, and owes $39,000 in child support.
How hard is it to hear them say you should have done more?
It ain't hard at all, because I already know I'm supposed to do it.
One moment, this Detroit man is angry at the state. He says his family reported concerns to CPS in years past, but it only caused problems as the kids were given back to their mom. The next moment, he is full of regret, wondering what if.
It's my fault. It's all my fault.
Blame yourself.
It's all my fault. Yes, it is.
One thing Dorsey wants his surviving daughter, who police say endured years of abuse, to know.
It's not our fault. Not our fault.
In Detroit, Kim Russell, 7 Action News.
Y'all was never there for Gabby and Stoney. But y'all want to hop on the news and act like y'all was.
Okay, I'm going to need you to keep it quiet, or I'm going to clear the courtroom. Just keep it quiet.
They were never there for my kids, ever. He is an alcoholic, never there.
Blair Berry children. Petition number 15001-623. Today we're here for a pretrial on original petition for permanent custody. All parties please state your name for the record.
Kelly Megacy, Assistant Attorney General on behalf of DHS.
Katrina Hayden, DHS CPS worker.
John Giancotti from CHAP, guardian ad litem.
Adam Devlin, appearing on behalf of Mr. Dorsey here.
Alexander Dorsey, Gabrielle's father.
Good morning, Laura Anderson, P51285. I represent the father of Matthew, that's Stephen Berry. He is not present today, and I don't know why.
Good morning, Your Honor. Janice Hill Burns, 35185. I represent the mother, Miss Blair, who stands to my right. Michelle Blair.
Okay, everyone can have a seat, and good morning, everyone. Sorry about the delay. We had a brief in-chambers conference with the attorneys before beginning today. This matter is here for pretrial today. We were last here March 26, 2015. That was for a preliminary hearing before Referee Bobak. At that point, the petition was authorized. Mother was visits were suspended. Fathers were granted supervised parenting time, and the matter was continued today in our docket for a pretrial hearing. So today we do have an amended petition that was filed just recently on April the 2nd, 2015. Ms. Megacy, you're asking for authorization of that petition?
Yes, Your Honor.
Do the parties have any objections and or statements prior to the court authorizing that petition?
No objection, Your Honor.
No statements, Your Honor.
Your Honor, I was just handed this amended petition this morning. I haven't finished reading it. Additionally, my client, Mr. Berry, is not present. I would ask for an adjournment for his presence. I did speak with him as late as yesterday. He was aware of today's date and time, so I would ask for an adjournment for his appearance, Your Honor. He was present at the prelim.
And Mr. Devlin, any statement?
Your Honor, I just received this today as well. I have not had an opportunity to read it with my client to review it. We'll accept it for now, though.
Okay, Ms. Burns, anything?
Well, for the record, Your Honor, I would indicate that at the prelim, Ms. Blair was supposed to be served. She was never served even with the original petition. I see it sitting on the table, the amended sitting on the table today, so I am assuming she was served while we were in chambers. Talking with the Attorney General from what the amendments are, I believe the court would find probable cause for it to go forth. So I have no objections, and I'll go over it with my client at a later time.
And then, Ms. Anderson, the court notes your objection, but the court is going to arrange for service on all of the parents today, and certainly authorization does not waive your client's rights to a full trial, either by a judge or jury in this matter. So the court is going to authorize the petition using today's date, which is April 8th, so that this matter can move forward. Do parties waive reading of the amended petition at this point?
Yes, Your Honor.
Now, I noted, Ms. Megacy, from the preliminary hearing order, it indicated that there were no issues known at that time regarding these children having Indian heritage. Do we know if that's still the case?
That's still the case, Your Honor. There's been no representations, no additional statements in the prelim where any of the parents have indicated American Indian heritage.
And Mr. Giancotti, anything new that you have on that issue?
Nothing new on that, Your Honor.
The other counsel, in talking to your clients, do we still believe there's no Indian heritage?
Your Honor, at the preliminary hearing, Ms. Blair indicated that there was not.
Okay, then with that, we need to arrange for service today. With respect to Mother and Mr. Dorsey, we can have them served today, and it appears that we already have a proof of service done. Mr. Dorsey was served, and the mother, Mitchell Blair, was served. So we still have to arrange for service on Mr. Berry. At this point, Ms. Megacy, we have a good address for Mr. Berry?
That's correct, Your Honor.
Okay, so the court will order service on Mr. Berry by personal service, certified mail. And with that, prior to setting the trial date, I know from our discussion in chambers that Ms. Megacy, you had a motion with respect to Mother at this point regarding the guardian ad litem for her.
Yes, Your Honor. It's my understanding that in the criminal case there is a mother requested a competency and criminal responsibility evaluation. Given that request, I'm not asking for any delay because it's not necessary in terms of the competency report to delay our hearing. What I am asking, however, is given that representation, that request, that she be appointed a guardian ad litem in this case.
And Ms. Burns, any response to that?
Well, the only thing I would say, Your Honor, is that, as I indicated in chambers, I would ask that I have a copy of any competency examination prior to hearing. I know we have a tender years hearing and then setting the trial date. So while an guardian ad litem may be helpful in talking with Ms. Berry, although I will indicate to the court that she and I spoke for over an hour yesterday, and I believe she was able to understand me. However, the competency examination will give me more insight into how to proceed.
Okay, what the court will do then, Ms. Burns, is you are her attorney, and certainly you have the lead role. I'll appoint the guardian ad litem and ask the guardian ad litem to speak with you prior to speaking with the mother, and allow the two of you to discuss the matter, allow the guardian ad litem to talk with the mother. And if you reach a conclusion as we approach trial that it's not necessary, then the court, of course, will remove the guardian ad litem and allow you to proceed on your own with representation of the mother.
Thank you, Your Honor.
And so at this point, prior to setting the trial date, any other issues we need to address today, starting with you, Ms. Megacy?
Other than I received a formal request from Ms. Anderson for discovery. We did discuss discovery issues in chambers. Obviously, when I receive documentation, I'll provide that to counsel as I receive it. The videos that are in question can be viewed at the office. We've already had a discussion in regards to that. You can contact the office to make an appointment to view the videos that are necessary for preparation in this case.
To turn to you, Mr. Giancotti, have you spoken to the two children? Are there other issues we need to address today regarding their care?
No, I've met with the children. They're doing well in their placement. I would just, the only request I have at this time is I know that therapeutic services were ordered previously. I would just ask for educational and tutoring services be ordered in the interim of the trial date.
In regarding the placement, do you believe that it's appropriate at this time for both children?
Placement's appropriate.
Mr. Devlin?
Your Honor, I would say that our discovery on behalf of Mr. Dorsey will be forthcoming. However, we did want to address the issue of his supervised parenting time, and we request that the parenting time for Mr. Dorsey and Ms. Anderson, so I'll make a similar motion on behalf of Mr. Berry, be unsupervised. There's no evidence to the record that he knew.
Unsupervised? He's never given a fuck about my daughters.
Just a moment, Mother. You're turning
Never. Never. You understand what I'm saying? I don't understand. It's the whole crew here now, but y'all was never there for them. How many birthdays did you miss? Mikey, his ex-girlfriend, did more for him than any of y'all.
Mom, you have to stop. This is a hearing. Your attorney...
Y'all was never there for them. You want to put on a show for the news, though?
Mr. Devlin.
Your Honor, he had no knowledge of any of the...
And Linda Dorsey, you going to get on the news and say what's absurd? They were raping my kids, period.
You can't be quiet until it's your turn.
You like a damn fool y'all putting on that show.
Step out here for a minute. Step out. You gotta step
You're raping my fucking kids. You pathetic ass bitch, and he's a fucking drunk. Now tell the truth on that.
Ms. Burns, we'll give you a chance to speak to the mother before we get to mother's parenting time, okay? Mr. Devlin.
Your Honor, he had there's nothing in the record that indicates he had any knowledge of the abuse that was going on. And in my conversations with him, he's indicated to me that he attempted multiple times to have a relationship with the daughter and was continually frustrated by the mother. He's just looking to use this opportunity to try to make his family as whole as possible and have these unsupervised visitations.
And before I rule on that, Ms. Anderson,
I would join in the attorney's motion and ask for Mr. Berry that he be allowed unsupervised visits with his son Matthew. There's no allegations that he was the perpetrator of any abuse. There's no allegations in the petition that he knew of the abuse. He did have a relationship with his son, and he has had a supervised visit since the preliminary hearing that I understand went well. As the court knows, the agency only provides parents 1 hour a week with their children. So my client would like to see his son more often. It can be accomplished through a combination of supervised visits, so the agency can continue to observe the interaction between Mr. Berry and his son, and also some unsupervised day visits. We think that would be in the child's best interest.
Ms. Megacy, your response?
Well, Your Honor, in regards to both fathers, this is the petition to terminate their parental rights. While the petition itself admittedly doesn't say that either father physically abused or tortured the children, this is a petition where the allegations are failure to protect. I don't want to argue the allegations at this point, but both fathers failed to support, care for their children for 2 years, at least 2 years. And for them to now come before this court and say we should be entitled to unsupervised visits is is alarming and inconsistent with the role they've taken in their children's lives up until this point. So I believe, given that this is petitioned to terminate parents' rights, a failure to protect petition, I'm asking the court for the order to remain as it was said at the prelim.
Based on the nature of the petition, the allegations, and the request for termination, I believe that the visit should remain supervised at this time. I don't think we have enough information as to the exact nature of the relationship the fathers had with their children in this period of time, and I don't think it would benefit them to have anything more than supervised at this time.
Ms. Haight, for a minute, have you observed any of the visits between Mr. Dorsey or Mr. Berry at this point and their respective children?
Yes, I have.
Can you tell us what you've seen in terms of the interaction between each of them and their child?
The interaction between Gabrielle and Mr. Dorsey was appropriate. They were talking, holding hands. Gabrielle was a little quiet in the beginning, but they talked throughout the hour. Mr. Berry and Matthew, in the beginning of the visit, it was kind of awkward. Matthew was playing and Mr. Berry was just following behind him. It was really no interaction with them directly.
How many visits have each of Mr. Dorsey and Mr. Berry had with their respective child at this point?
One.
Just one visit?
Just one visit.
Okay, what the court will do is the court's going to continue the order for supervised visits for Mr. Dorsey and Mr. Berry at this point. We don't have enough of a baseline at this point, given that each of them has only had one visit with their child. But Mr. Devlin and Ms. Anderson, once we have a wider group of visits to look to, you certainly are welcome to renew your motion. I'll consider it after we've had more visits so that we can get greater feedback on how things are going from the caseworker. Okay, so with that, any other issues prior to setting the trial date at this point? Any party? Okay, so we've discussed trial dates at our conference in chambers, and we've agreed at this point that trial starting on June 4th at 10, moving into June 5th, and then June 11th are dates acceptable to all counsel in this matter. Is that correct?
That is correct, Your Honor.
And we're going to begin on June 4th with a hearing under MCR 3.972, correct, Ms. Legacy?
Yes, Your Honor, I'll file that motion. I expect to have that motion filed by the end of next week.
And once we complete the tender years motion, we'll move straight into trial either on the remainder of June 4th or starting on June 5th.
Procedural question, Your Honor. Did the court want to set a date for responses to the motion?
I will order the motion to be filed by April 17th, Friday, April 17th, and any response to be filed by Friday, April 24th.
Thank you, Your Honor.
Anything else for the record today? By anyone? No. Okay, we're adjourned. Have a good day, everyone.
You can probably exit quietly.
He usually does them straight through.
Say why you were late to the hearing?
Mr. Berry, can you just talk to us how you feel?
Mr. Berry, we haven't had a chance to talk to you yet. What can you tell us?
He tried to be there for them. He would try to call, try to come over, and there's just a strenuous relationship between the two, and that always made it difficult.
Some would suggest he didn't do enough, that one of these kids, his kid, was in this freezer for as long as 2 years.
Many people didn't do enough in this to have a child dead for multiple years in a freezer. Whether my client has some level of blame in that, I don't know, and that'll be up for the judge to decide.
Blair herself admits to killing her 2 children, and she is angry when she puts much of the blame on the children's 2 fathers.
You! Everybody want to know? Yes, I did kill her!
In a lightning bolt of emotion, Michelle Blair admits to killing her 13-year-old daughter, Stoney Blair, because she believed the teen and her 9-year-old son, whom she's also accused of murdering, had been harming her youngest child. Blair is charged with their murders, but the trial that began today is about the state attempting to terminate Blair's parental rights to her 2 surviving children and terminate the rights of both fathers. An attorney for the state suggesting Stephen Berry and Alexander Dorsey are deadbeat dads who didn't care about any of their children until 9-year-old Stephen Berry and 13-year-old Stoney Blair were found dead in their mother's freezer earlier this year. Investigators believe Blair killed little Stephen first in 2012 and put him in her freezer. Then they say a year later Blair killed her 13-year-old daughter. Prosecutors say her dad knew there was abuse.
What happens when your kids come to visit you in 2005?
Sister gave him a bath, seen whips on his back.
Who's seen whips?
My sister.
Your sister. Did you see these whips?
She showed them to me.
Are these long red marks?
No, they was healed up by the time I seen them.
Healed up. But do they appear to be long, like lines?
No, it's like slashes.
Another one of Michelle Blair's outbursts came as an attorney for one of the fathers was addressing the court.
So I asked the court not to be so inflamed by the mother's actions as to place those on my client. The allegations against my client, Mr. Berry, are failure to protect and abandonment.
And never being there for his kids.
Mother,
She was
stop.
always on sex sites, though,
Mother,
right?
mother, listen to me.
I had to beg you to come see me. For real,
Mother, listen to
no
me.
matter how much you lie or how your lawyers lie.
You done, Mother? Listen to me. This is a civil case. It's not a criminal case. We can and we will do it without you.
I never
We
tried to
will
say I
do it
didn't. I
without
did
you.
it, but that does not negate the fact that they were never there for their children. I had to struggle with them all the time. They were never there.
You get
Stephen,
your
you
chance.
know we had to beg you. Me, Stephen, all of us used to cry for you.
You're not going to be able to
I'm
stay,
good.
Mother.
Come here.
There are rules.
And deputies had to take Michelle Blair out of the courtroom once again. And then there was also a moment when the judge was talking about Blair's youngest son, telling a social worker that he saw his mom kill his sister and brother. Blair then blurted out at that moment, quote, "He didn't see me kill Stephen because it was unintentional." The trial resumes tomorrow morning, and we will certainly be there. Reporting live in Detroit, Kimberly Craig, 7 Action News. Back to you. And Carolyn and Glenda, you talk about heartbreaking. This is probably one of the hardest cases I've had to sit through in my 20 years of reporting. And it was so sad to hear the medical examiner talk about how these children had been beaten and were so grossly malnourished. Even the court reporter could be seen wiping away tears. These are photographs taken from inside the townhouse where investigators say Michelle Blair tortured her children and killed 2 of them. We're told she first killed her 9-year-old son, Stephen, in August of 2012 and then shoved his body in this freezer. About a year later, Blair is accused of killing her 13-year-old daughter, Stoney, and putting her body on top of Stephen's.
Both had been slapped in the face. Both of them had chipped teeth, and both of them had actual tears in the mucous membrane of the inner aspect of the lip.
Dr. Carl Schmidt from the Wayne County Medical Examiner's Office says it took 2 days to thaw the children's bodies before he could examine them, and what he found was nothing short of horrifying. On 13-year-old Stoney, he says the blows to her head were too many to count.
And actually the entire scalp was suffused with hemorrhage, which meant that she had received numerous impacts over the head.
And then there's 9-year-old Stephen, who we're told had countless burns all over his body.
When we see patterns, burn patterns like this, it means that there was some kind of object with 4 parallel lines which left the brand. It's like branding. You left that pattern on the skin.
In this custody trial, the state is trying to terminate Michelle Blair's parental rights to her 2 surviving children, as well as their father's rights. The state calling them deadbeat dads who rarely saw or even called to check in on their children to see if they were okay. Before he found out his son had been killed, it had been 5 years since Stephen Berry had seen his son Stephen. Berry was locked up for a couple of those years, but he was released from prison in the spring of 2013. And he says Michelle Blair only let him see their youngest son and told him Stephen was mad at him. What he didn't know was that Stephen was already dead.
I didn't speak to him
at all after my incarceration.
Why?
Because I was told that he was mad at me for not contacting him or, being there.
And that just adds to the heartache for these children. They had been dead for 2 to 3 years, and not even their own fathers fought to see them or even talk to them. But now they are blaming, apparently, CPS, Child Protective Services, for not removing the children in 2005 when CPS actually found and determined there to be abuse in the house. One of the fathers, Carolyn tells me, the father of Stony Blair, says he now plans on suing the state. Back to you.
Kim, real quick, we just saw her sitting there stone-faced, no outbreaks today. She seemed so violent and volatile yesterday when she was in that courtroom.
She had a couple of outbursts. Really, they were rather ridden with expletives, so we couldn't really, it would have been a lot of beeping going on. But nothing as violent as yesterday, but you can see when she is sitting there and when she is listening to testimony that she is angry. She is very angry. She still maintains that she has love for her 2 surviving children. She says she will always be their mother, but she does not acknowledge the life or death of the 2 dead children. Back to you.
All right, Kim, I know it's...
You! Everybody want to know? Yes, I did kill her!
Hard to believe a woman who admits to killing her 13-year-old daughter and torturing her 9-year-old son until he also died could be called a caring mother by anyone. But Victoria Johnson says that's the Michelle Blair she knew.
She was very protective of her kids, of all kids, not just her kids.
She says she once overheard Blair begging one of her daughter's fathers for food.
This was like her 3rd or 4th phone call that day that I seen, and he was drunk. And he wouldn't bring them nothing to eat. And she was crying because she didn't have a way to the soup kitchen to go pick them up some food or no money to buy them no food. So we got them food. And I took her to the soup kitchen to get them food.
Attorneys for the children's fathers, Alexander Dorsey and Stephen Berry, say the state is to blame because they were aware of abuse in 2002 and 2005 and did not see fit to remove Blair's children. The state says if both fathers were ever around long enough or cared enough, they would have seen the continued signs of abuse all over the children's bodies. Dorsey admits he hadn't seen his daughter Stony in over 2 years before he found out she had been killed and shoved in the freezer.
Did Mr. Dorsey say, we really got to keep an eye on the girls and keep checking them for any injuries?
No.
That was never discussed after 05?
No.
Like Dorsey, the state says Stephen Berry should also lose his parental rights to a surviving son because he was also missing in action when it came to being a dad.
Did Mr. Berry indicate when the last time he had contact with his children was?
He stated in 2012.
The judge could make his decision on whether to move forward with stripping all 3 parents of their parental rights when the trial resumes later this month. In Detroit, Kimberly Craig, 7 Action News.
Today was here for continuing bench trial on original petition for permanent custody. All parties please state your name for the record. Kelly Legacy, Assistant Attorney General on behalf of DHHS.
Katrina Hayden, CPS investigator for DHHS.
John Giancotti from CHAP, guardian ad litem.
Adam Devlin, attorney for Alexander Dorsey.
Good morning, Laura Anderson, P51285, represent the father, Stephen Berry. Please state your name.
Stephen Berry. Good morning, Your Honor. Janice O'Burns, 35185, counsel appointed on behalf of Michelle Berry, who stands to my right. Blair, I'm sorry. Stands to my right. Michelle Blair, mother Gabrielle, and Matthew. Good morning, Your Honor. Tracy M. Martin, P63745. I appear as guardian ad litem for Ms. Michelle Blair.
Okay, everyone can have a seat. We set today's date for closing arguments and for decision by the court. We were last here June 11th, 2015, and we did complete everyone's testimony at that point, and along with any potential rebuttal by Ms. Legacy. But we did have a chance to have in-chambers discussion with the attorneys this morning, and we do have a preliminary matter that I did discuss with all counsel, but specifically as to you, Ms. Burns, and that is that the court did receive 2 different letters from the mother, and while the court doesn't specifically read the letters, and I did return them to you so that you would have them, the court is aware of two issues that the mother raises, one being her counsel, and 2 being that she wished to provide some testimony to the court. So Starting with the counsel, let's take that issue.
Thank you, Your Honor. Yes, I understand the letter Ms. Blair asked to have me removed as her counsel based upon the fact that I did not, and at the point until yesterday, could not call her as a witness. I stand ready to stand down if the court desires.
Anyone else wish to weigh in on that issue? I'll give you a chance to others. Anyone want to just check with the other counsel?
No, Your Honor.
Mr. Mason, Mr. Duquette.
Judge, other than to ask the court to obviously take judicial notice of what has occurred during this trial, Ms. Burns is one of the most capable and efficient attorneys in this courtroom regarding on these cases. I have nothing further to add.
And Mother, can you speak?
Yes. Basically, I don't deny that she's a victim and she's a good lawyer, but she did, in fact, violate my right to testify. Mr. Burns, I'm sorry, Mr. Harris, which is my criminal trial lawyer, was speaking directly to her, and as a direct result of that, she stopped me from testifying because she was basically thinking it was going to hinder something as far as me incriminating myself in my criminal trial, but I was explaining to her how much more could I incriminate myself if I've already publicly confessed more than 3 or 4 times. And my biggest thing to Ms. Burns was she kept giving me the runaround through all 3 dates of the testimony, the 3rd, the 4th, the 5th, and the 11th. I told her I don't care. Put me on the stand. She didn't, to me, she did not understand that I have a right and a say-so in my own defense. You get what I'm saying? She kept saying, oh, well, Mr. Harris doesn't think that it'd be a good idea if you get up there. And I'm saying, well, how else can the judge understand that Stephen Barry and Alexander Dorsey were never there for their children? They don't care for me.
Your Honor, I object to Mother's testimony regarding
But it's true.
We're not going to take any specific testimony, but your request basically is based on the fact that you wanted to testify.
Exactly.
And that's the main reason for your request for
And I was not being heard by her, so which made me not trust her as my lawyer. If I can't trust her as my lawyer, why are you my lawyer?
Okay.
Well, Your Honor, just the only thing I will put on the record is I heard her and I understood her. But I have an obligation as a lawyer licensed in this state to protect the client's constitutional rights, and that I did.
Your Honor, I also told her I understand what she has to do as a lawyer, but this is my trial. I'm on trial. My child I need to fight for. So everybody can understand on record how they were truly as fathers. I also told her my daughter Gabrielle needs to be called to testify against them too. Why? Because of course nobody wants to hear me. They're not, in light of what I did, nobody's going to believe me, and I do understand that. So my daughter Gabrielle is 17 now. She is the only one other than me that knows in total detail and witnessed everything that went on with Stephen Barry and Alexander Dorsey and how they weren't there. So I would definitely want her to be called.
Well, let's just take one issue at a time. So on issue number 1, the main problem is that Ms. Blair wanted to testify. There really are no other issues with Ms. Burns' representation. As indicated, Ms. Burns certainly has a wealth of experience in these kinds of matters. So with respect to the request for a new attorney, the court's going to deny that. We are well over 2/3, 3/4 of the way through this trial. And so to start over would just be foolish at this point. So the court was going to deny the request for a new attorney. But our second issue is the mother's request to testify. So, Mother, you have a seat for a minute. Let me just hear from Ms. Burns first. Ms. Burns, I know that she wants to testify. Can you give us an offer of proof as to what issues the mother's testimony would go to?
Well, the offer of proof is basically just what Ms. Blair was saying to the court. She wishes to testify with regard to the issues of Mr. Barry and Mr. Dorsey in terms of what was said from the stand and what has not been said from the stand, in terms of the fact that her testimony would be that they were not there, that they had never been there for their children, that they have issues in terms of conduct and character that would go to jurisdiction.
Does any of her testimony go to the question of whether or not the court has jurisdiction over the 2 children, or whether or not the court has a statutory basis to terminate specifically mother's rights, leaving the fathers to the side?
As I understand the court's question, the court is asking whether or not any of the testimony that Ms. Blair will give goes to her actions towards jurisdiction.
Whether we would have jurisdiction through her, or whether we would have a statutory basis to terminate her rights.
It would be only in combination with the behaviors and character flaws that I indicated she would testify to for Mr. Berry and Mr. Dorsey, along with herself, in combination.
Anyone else wants to weigh in? Let's start with you, Ms. Madison.
Judge, we had a discussion in chambers about this. As the court indicated, the only party that could potentially be prejudiced by mother testifying at this point would be the Department of Health and Human Services, because we are the only party at this point that can call rebuttal witnesses, and as the court indicated, mother would have been one of the last witnesses. I don't have anything further to add than that.
I have nothing to add on this, Your Honor.
Mr. Devlin?
You know, I would just say that her job is not to prove the petitioner's case, to establish the burden of proof. Her job is to defend herself. She's going to be offering testimony that is going specifically towards my client's statutory grounds for termination. I don't see how that has any relevance to the reasons that she was not called as a witness to convolute her criminal trial. She could have got up there at the time, and I request that we deny her to be a witness.
Thank you. On behalf of Mr. Berry, I agree and adopt into my response his response, but I would add that Ms. Blair did have the right to testify at this trial. She could have testified as to her position regarding the fathers. That would not have incriminated her. This is a civil matter. She could have been called. I would have objected to her testifying to such. It doesn't go towards anything having to do with whether or not her rights should have been terminated. And further, Ms. Blair is free to testify at the best interest hearing. So she will have an opportunity to provide information she wants to the court regarding anybody related to this case. So if there was an error in her not testifying, it's harmless. The court already has Ms. Blair's written statement entered into evidence in which she admitted killing the children. Ms. Blair reminded the court today that she also admitted publicly several times prior to closing the case that she's killed the children. So clearly there are grounds as to her. From her attorney's own statements, she's not wanting to testify at this phase having anything to do with grounds against her. It really goes towards best interest to the father, Your Honor. Thank you.
Well, I will just respond to Ms. Anderson, Your Honor. First of all, she would not have had a right to object to the mother testifying and a right to object in cross-examination that I made if I had chosen to call her as a witness, in terms of if that was against the father or if it was against the mother. So that is something that is non-plus in terms of an argument. With regard to, yes, mother still has an opportunity and a right to testify as to best interest. But Ms. Blair has indicated to this court and to myself that she wishes to have her proofs reopened so she can take the stand and make her statements and her testimony. I have given the court an offer of proof based upon what my client has said even this morning as to what her testimony will be. Obviously, it will be against the two fathers. Obviously, it will also be against herself.
Okay, thank you, Ms. Brown. The issue is, with respect to Ms. Blair, is that certainly if you raise the issue that you had a disagreement with your attorney regarding the progression of the case, if the testimony that you did not have an opportunity to offer went as to your side of the case, and it's some bearing on your side of the case versus bearing on what the court should do with the fathers, the court would likely reopen the proofs. And of course, if the court had to do that, then it would have to give the agency an opportunity for rebuttal because they already passed up on their opportunity for rebuttal. But given that, as indicated by the offer of proof, that the testimony that you would offer would not necessarily go to the questions that are on the table regarding you today. And as we indicated before, there are multiple questions in these type of cases. The two questions that are on the table regarding you today are, one, does the court have jurisdiction or temporary custody over your two surviving children because of your actions? And number two, then does the court have a right to terminate, authority to terminate your parental rights based on your actions? Those are the two questions relating to you. And your testimony, if the court were to reopen it at this point, would not go to those issues. I would agree that perhaps if we get to a best interest hearing, depending on the outcome after today's closing arguments in the court's decision, that if we get to a best interest hearing, perhaps your testimony would be probative on the best interest questions, depending on which parents were deciding about at that point in time. But in terms of the statutory basis of jurisdiction, the court doesn't think that your testimony will change or have any relevance to those questions. So I'm going to deny your request for today. If you wish to testify, and if we get to a best interest hearing, then the court will entertain that on July 26th. So that's the question.
Can I say one thing?
Speak to your
Should it be hard?
Speak to your attorney first.
He wants to know what you want to say. Yeah, and for the record, what Ms. Blair wants to make a statement is regarding it was a jailhouse recorded conversation between she and Mr. Berry.
And he indicated that he was definitely going to lie.
The court, like I indicated, the court, if we get to best interest hearing, the court will entertain that testimony. It appears that it's more of a best interest question than it is a statutory basis question. So the court will allow you to raise that request again if we get to a best interest hearing on July.
What about my daughter?
Once again,
the court appears you haven't heard anything, you have not heard the truth about Alexander or Stephen Berry. So I'm actually requesting to take a polygraph test about both of them.
You can speak to Ms. Burns about it, but once again, those are issues that would come up for best interest. They don't bear on the two questions that the court has to decide regarding your case today. So if we get to best interest hearing, you can discuss that with Ms. Burns, and the court, of course, will allow you to present that testimony at best interest, depending on which parents are involved in the best interest. Okay, so that's now. Any other preliminary matters before closing?
Yes, Judge, before we get to closing, I did tell Ms. Burns that it's been addressed peripherally. I would ask for a stipulation that as of yesterday, Ms. Blair did in fact tender a guilty plea to felony murder and premeditated murder in regards to Tony, Blair, and Stephen Berry.
Obviously, Your Honor, with the amount of coverage on that, there was a plea made before Judge Dana Hathaway yesterday. My understanding that the sentencing is not until July 17th before Judge Hathaway. So, I mean, the fact that she made the plea, yes. Actually, and the court accepted it. There has not been a sentencing, so she can do it. She can withdraw it even until the 17th. So I can stipulate that it was made. There hasn't been a sentencing yet.
The court did not accept the plea at this point?
The plea was accepted, but there's been no, I would agree there's been no conviction per se because she hasn't been sentenced yet. So that's the reason I'm not seeking to amend the petition to include those statutory grounds regarding incarceration for 2 years or convicted of homicide, because there is no conviction technically in the criminal sense until there's been a judgment of sentence.
Exactly, Your Honor, so that actually at this point, the fact that she has made a plea really doesn't change what would be or could be the bases of this court's jurisdiction with regard to Ms. Blair.
Right, that's true. So the court, if you wish to introduce that at our best interest hearing, if we get to that point, you could certainly introduce that on the July 27th. Apparently the sentencing on the criminal case will be done at that point. I don't think it's probative at this point.
It's just another admission. It's just a stipulation I wish to have for the record. And secondly, in terms of Mr. Berry, I told Ms. Anderson that for clarification of the record, we would stipulate that at the time of Stephen Berry, the child's murder, Mr. Berry, his father, was in fact incarcerated in the Department of Corrections, released in April of 2013. I told her I'd make that stipulation.
Well, that was set forth by the testimony.
Right.
When he testified, he indicated he was incarcerated from December 2010 to April 2013.
Right. I just wanted the record clarified in terms of my agreement with that stipulation.
Any other preliminary matters before closing arguments by anyone? All right, then we'll start with you, Ms. Brady.